It's time for another round of Fannie Mae guide updates. The updates from May are pretty straightforward, but the following highlights are worth noting. For all details, please refer to the selling guide updates on the Fannie Mae website. The first update is a joint effort with Freddie Mac to further define a first-generation homebuyer. For a borrower to meet this definition, they must meet the following requirements. Purchasing the subject property will reside as a primary residence and has no ownership in another property within the last 3 years. In addition, one of the following must also apply. 1. No parent of the borrower has had an ownership interest, sole or joint, in a property in the last 3 years preceding the note date of the loan. 2. The borrower has aged out of foster care. Or 3. The borrower has become emancipated. Fannie Mae has developed a framework for lenders to review and respond to a borrower-initiated reconsideration of value. The lender's policies and procedures must include steps for the borrower to appeal an appraisal when they believe the opinion of value is unsupported, is deficient due to unacceptable appraisal practices, or reflects prohibited discriminatory practices. Regardless of the outcome of the reconsideration of value, the lender is responsible for ensuring the appraisal report and opinion of value are reliable, adequately supported, and that the borrower's concerns with the valuation are addressed in a timely manner. The updated policy includes specific instructions for the borrower disclosure that must be provided at the time of loan application, and again upon delivery of the appraisal report, as well as lender requirements for reviewing and responding to both the borrower and appraiser. Lenders are encouraged to implement these policies immediately, but must do so for loans with applications dated on or after Aug. 29-2024. Next, it has been clarified that an affidavit of a fixture is only required when a loan on manufactured housing is delivered with a personal property title and the borrower's intent is to convert to real property. If the manufactured home was previously converted to real property in accordance with applicable law, Fannie Mae will not require an affidavit of a fixture unless applicable state law requires a new affidavit. And now everyone's favorite topic, trust income. In this update, Fannie Mae clarified policy regarding trust income to include the following. 1. Trust verification documentation must clearly identify the date the trust was created so lenders can appropriately apply the policy. 2. Trust verification documentation may include a letter from an accountant or attorney who has reviewed the trust documentation when the trustee's statement or other documents are not available or when the borrower is trustee. 3. Trust created within 12 months of the loan application date and funded by the borrower's employment-related assets may still be used as income, but must meet the income calculation and all other requirements for employment-related assets as qualifying income. 4. When variable trust income has been received for less than 24 months, but not less than 12 months, the lender may consider it as stable income when other positive factors are present that reasonably offset the shorter income history in alignment with the standard variable income guidelines. For variable trust income, lenders may rely upon copies of the trust's federal income tax returns as an alternative to the borrower's personal tax returns. For additional information on guide updates, please reference the Fannie Mae website. For additional assistance with contract processing, underwriting, quality control, condo reviews, and consulting services, please reach out to us at the Commonwealth Group at info@thecommonwealth.net. Have a great day.